Hello, everyone, and welcome to Uncivil Law. I hope you're well. For today's case, we have a decision from the 10th Circuit Court of Appeals in the case of Warren McCowan versus the city of La Cruz, New Mexico. In this case, Mr. McCowan was arrested by the police. He alerted them that he had a shoulder issue. Despite this, the police put him handcuffed without a seatbelt in a cop car and then proceeded to recklessly drive as he bounced around in the back of the seat like a ping pong ball. He complained about this maltreatment, but the cops laughed at him. At a later time, while he was complaining, the police mishandled him to the degree his shoulder audibly ripped as they were mishandling him. Yet the police continued to laugh at him. He is suing for a violation of his civil rights. So let's see what the story is with this and whether or not he can sue the police for maltreatment or whether or not the police will escape on a 1983 immunity. Let's get started. In this interlocutory appeal, which means, by the way, that the appeal is occurring during the middle of an ongoing trial instead of the end of a trial. So the trial is still ongoing. They're appealing in the middle. That's what interlocutory means. Defendant Mark Mozelis, a Las Cruz, New Mexico police officer, challenges the district court decision to deny him summary judgment on the basis of qualified immunity from two of plaintiff Warren McCowan's 1983 claims. McCowan based his excessive force claim on the assertion that Officer Morales placed McCowan in the backseat of a patrol car, handicapped him behind his back and unrestrained by a seatbelt, and then drove recklessly to the police station, knowing his driving was violently tossing McCowan back and forth across the back seat. As to this claim, it was clearly established at the time of the events that an officer's gratuitous use of excessive force against a fully compliant, restrained, and non-threatening misdemeanor arrestee is unreasonable and therefore violates the Fourth Amendment. Thus, we agree with the district court that Officer Morales is not entitled to qualified immunity from McCowan's excessive force claim. With that prelude out of the way, let's discuss a little bit more of the facts of what occurred that fateful evening. After almost midnight on August the 21st, 2015, Officer Morales pulled McCowan over for driving without headlights. McCowan had red, bloodshot, watery eyes, a flushed face, slurred his words, smelled strongly of alcohol, and had a 30-pack of beer in his back seat. He admitted he drank 3 beers 1 to 2 hours earlier. So far we've got a very justified DUI stop going on. So that's perfectly fine. The police arrest people for DUI literally every day and multiple times per day. And so this is not new, so it's like, treat it like a DUI, we know how to deal with this. McCowan agreed to take a sobriety test, but before doing so, he informed Officer Morales that he had a pending Social Security disability claim for a neck and shoulder injury. After McCowan performed poorly on the sobriety test, Officer Morales arrested him. As he was handcuffed, McCowan claims he requested the cuffs be let loose and forward-facing so as not to aggravate his shoulder injury, but Officer Morales refused because he suspected McCowan was lying about his injury. Once handcuffed, McCowan was placed in the back of Officer Morales' police car and driven to Las Cruces Police Department, which took 2 minutes and covered 0.8 of a mile. McCowan asserts that he was not buckled in, and as a result of Officer Morales' fast, jerky driving, was repeatedly slammed throughout the backseat like a ping pong ball. McCowan begged Officer Morales to slow down, but McCowan claims Officer Morales laughed at him and continued to speed. McCowan believes his being tossed around re-injured his shoulder. So he's being given a rough ride by the police, which is not a good thing to do. This is something we've heard about, and we've heard about in that Baltimore incident as well, where someone died in the van as a result of apparently this too, of this rough ride where the police will purposefully behave this way so as to injure people. There's no reason to do it. It's not legal. It's just vindictive. It's pain for pain's sake. So, stop doing that, people. Jeez. McCowan was placed in a holding cell with the police department where, consistent with protocol, he was handcuffed to a metal bench. Because of his searing shoulder pain, McCowan requested he not be handcuffed. When that request was denied, McCowan pleaded to be handcuffed from the front, which was also denied. McCowan asserts that he continued to cry and scream in pain and begged the officers present, including Officer Morales, to loosen his handcuffs. According to McCowan, the officers laughed at his request. It's not really super encouraging. The police were laughing when he's crying and screaming in pain. That's not really like super duper encouraging there. That, maybe a little bit more human compassion would have been the way to go. At some point, Officer Morales entered McCowan's cell to prepare his transfer to the Donna Ana County Detention Center. According to McCowan, Officer Morales slightly loosened his handcuffs upon discovering McCowan's wrists were purple. He then ordered McCowan to stand up straight, but McCowan was unable to do this because he was handcuffed in pain. With the assistance of other officer, McCowan was pulled off the floor, causing his shoulders to audibly tear. That is pretty horrific. Wow. That's truly horrible. And of course, at this point, the police realized their mistake and got him immediate help, right? McCowan screamed in pain, but no medical treatment was offered or provided. McCowan was then taken to a detention center where he was medically cleared and booked despite telling booking officers he was in excruciating pain. Really thorough review there you did on the medical clearance issue there, man. Real thorough issue you did. Jesus, what are you doing? Lord. Following his arrest, McCowan had 2 shoulder surgeries and accumulated nearly $120,000 in medical bills. In February 2016, his DUI and failure to use headlamp charges were dismissed without prejudice. With that horrific factual background out of the way, we're now going to get into the law that applies and whether the officers can be held to account for civil wrong for this action. Can he sue and recover? Let's find out. McCowan sued Officer Morales and his employer, the city of Las Cruces, asserting claims under 1983 and New Mexico law. Officer Morales moved for summary judgment on the basis of qualified immunity. A court can consider the 2 qualified immunity inquiries whether a plaintiff has established a statutory or constitutional violation and whether that violation was clearly established in any order. McCowan asserted that Officer Morales used excessive force against him when the officer placed McCowan, handcuffed but unrestrained by a seatbelt, in the cage back seat of the patrol car and then drove recklessly, knowingly tossing McCowan about the back seat. Although we briefly addressed whether McCowan established a constitutional violation, he did, we focused primarily on the question of whether the violation was clearly established at the time of the events because that is the focus of Officer Morales' argument on appeal. So just so we take note of the argument on appeal, his argument was, on appeal, it was not clearly established at the time that I couldn't massively mistreat a prisoner in this particular way. As a result, I have immunity. Just taking note. Let's find out what the court had to say. A Fourth Amendment excessive force claim is governed by a purely objective standard. A police officer violates an arrestee's Fourth Amendment right to be free from excessive force during an arrest if the officer's actions were not objectively reasonable in the light of the facts and circumstances confronting him. The specific essential facts presented here, as we accept them for the purposes of this interlocutory appeal, are the gratuitous use of force against a fully compliant and subdued misdemeanant arrestee who posed no threat to anyone. This does not sound like the guy you need a lot of roughhousing for. Officer Morales inaccurately compares this case to a dissimilar situation where officers simply failed to seatbelt a handcuffed prisoner who was then injured in a vehicular accident due to the driver's officer's negligence. This is not what McCowan has asserted happened here. Instead, McCowan affidavit states that Officer Morales, after placing the handcuffed McCowan in a backseat unrestrained by a seatbelt, drove recklessly. McCowan pleaded with the officer to slow down and stop taking such sharp turns. Officer Morales laughed and continued to drive recklessly. As a result, McCowan was tossed about and ended up on the opposite end of the patrol cart's back seat. This is a different scenario. I agree with the court. This is different. He's behaving in a deliberate way to cause harm. It's pretty different than just mere negligence, yes. The real focus of Officer Morales' arguments on appeal is whether this Fourth Amendment violation was clearly established in August 2015. To be clearly established, ordinarily there must be prior Supreme Court or 10th Circuit precedent or the weight of authority from other circuits that would have put an objective officer in an officer's position on notice that he was violating the Fourth Amendment rights. The need for specificity is especially important in Fourth Amendment excessive force cases because it is sometimes difficult for an officer to determine how the relevant legal doctrine, here excessive force, will apply to the factual situation the officer confronts. Use of excessive force is an area of law in which the results depend very much on the facts of each case, and thus the police officers are entitled to qualified immunity unless existing precedent squarely governs the specific facts at issue. Nonetheless, even in the Fourth Amendment context, there need not be a prior case directly on point so long as there is existing precedent that places the unconstitutionality of the alleged conduct beyond debate. So here the court is rightly pointing out that it's hard and many times to have an exact case on point. But as long as the case law is clear that would put it beyond any debate, it's fine. And as the court is pointing out here, this is beyond any debate. This is horrific. So no, you don't get immunity. Go away. Officer Morales asserts there is no prior Supreme Court or 10th Circuit excessive force case involving an officer driving recklessly so that he knowingly tossed about the backseat of his patrol car a handcuffed but otherwise unrestrained arrestee. Therefore, Officer Morales contends that he was not on notice that when he did, as he did, that it violated the Fourth Amendment. But the relevant inquiry here, as the court explained to McCoy, is whether there was relevant 10th Circuit cases giving Officer Morales notice that the gratuitous use of force against a fully compliant, restraint, and non-threatening misdemeanor arrestee was unconstitutional. There certainly was. So, there's not exact case on point, you're right, but the issue is, can you behave like a complete dick to someone who doesn't deserve it, who's not presenting any threat, and completely maltreat him and rip out his shoulder and give him no treatment and laugh in his face? No, that's a bit much. You can't do that. You knew better. So no, you don't get immunity. Man, thank you, court, for finally saying that. Jeez, it's so blindingly obvious. You should have known. No duh, right? Man, but I'm glad they came out with that decision. I can tell you that. We begin by determining the salient factual comparisons of McCowan's claim. We find 6. McCowan was being arrested for a non-violent misdemeanor. He was handcuffed behind his back and not restrained by any seatbelt, rendering him vulnerable because he was incapable of protecting himself from the rough ride to the police station. He was compliant during the arrest and posed no threat to Officer Morales or anyone else. Officer Morales knew of McCowan's extra vulnerability because of his injury. There was no law enforcement necessity nor reason even advanced for the rough ride that resulted in McCowan being slammed from side to side in the police car. McCowan contemporaneously and unmistakably complained of severe pain and injury during the officer's challenged conduct. McCowan alleged that Officer Morales was deliberately indifferent to a serious medical need, his injured shoulders, while at the police station and until officer transported McCowan to the detention center while medical care was available. Because this claim adequately alleges a clearly established 14th Amendment violation, the district court correctly denied Morales qualified immunity from it. The claim we address here is that Officer Morales was deliberately indifferent to McCowan's serious medical needs, his injured shoulder, while the officer held McCowan at the police station and before the officer delivered McCowan to the detention center. But because medical care was available to McCowan at the detention center, even though he chose not to avail himself of it, and because McCowan asserts no deliberate indifference claims against the detention center or any of its employees, his claim at issue here is that Officer Morales was deliberately indifferent when he delayed McCowan's access to medical care during the time Morales held McCowan at the police station up to 150 minutes, which for those of you doing math at home is 2.5 hours, which is a pretty long time when you're in constant searing pain from your shoulder being ripped out, I would imagine. The 14th Amendment entitles pretrial detainees to the same standard of medical care owed to convicted inmates under the 8th Amendment. To succeed on the 14th Amendment claim, then, McCowan must show deliberate indifference to his serious medical needs. Turning first to the objective prong, the objective component of deliberate indifference is met if the harm suffered rises to a level sufficiently serious to be cognizable under the cruel and unusual punishment clause. Here, McCowan does not allege that any delay in Officer Morales getting McCowan to the detention center, where he could have sought medical assistance, caused the need for McCowan to have shoulder surgery or otherwise exacerbated his shoulder injuries. But McCowan does assert that Officer Morales' delay in getting McCowan to the detention center resulted in McCowan suffering up to several hours of excruciating pain. That is sufficient to meet the objective prong of the deliberate indifference test. So here the court is pointing out that objectively, what the officer did was horrible. He did basically cruel and unusual punishment to this guy, objectively, by not responding to his medical needs. And in doing so, he violated his rights by causing him to suffer several hours. That is a bad thing to do. You can't do that to people, and people in custody in particular, to whom the police do actually have a duty because they're in custody and they can't take care of themselves. So here the court is finding, yes, this is an objective violation on subjective merits. But what about subjectively? What about the officer's mindset? Let's read on. Next, turning to the subjective prong, the prong addresses whether Officer Morales acted with a sufficiently culpable state of mind. Here, the district court determined that, through his affidavit, McCowan presented evidence from which a jury could find that Officer Morales knew that McCowan was suffering from significant shoulder pain. McCowan attested that he told the officer that he previously injured his shoulder and that he'd re-injured his shoulder during the ride to the police station. And at the police station, McCowan repeatedly told the officer he's in excruciating shoulder pain. Yet, Officer Morales disregarded all that information in delaying McCowan's medical care for approximately 2 hours until he was sent to the detention center. That is sufficient to meet the subjective prong of the deliberate indifference test. We conclude, therefore, that McCowan succeeded in alleging a claim that Officer Morales was deliberately indifferent to his serious medical need. And thank God for that, man. Thank God that a court somewhere was willing to hold an officer to account for massive mistreatment of a prisoner. You know, this guy was in violation of the law from being a DUI. He deserved to be taken to the jail and detained and potentially prosecuted and suffer the repercussions from that act. But he doesn't deserve to be completely maltreated and physically injured for no reason and no cause. You know, that's not law. That's just brutality. And you know, that's not appropriate. And the officers here behaved in a way that is not becoming their fellow man. The district court further concluded that Officer Morales' alleged deliberate indifference to McCowan's considerable shoulder pain stated a clearly established constitutional violation. We agree. Morales adequately alleged that Officer Morales violated the 14th Amendment by his deliberate indifference to McCowan's considerable shoulder pain while McCowan was being held at the police station. Moreover, this constitutional violation was clearly established at the time of the incident, August 2015. The district court therefore properly denied Officer Morales qualified immunity on this claim. It will remain McCowan's obligation, of course, to prove the remedial value of this unnecessary pain he alleged the officer caused McCowan for the relatively short duration of time until he was transported to the detention center, but that is a matter of trial. So that is the end of the case of Warren McCowan versus the city of Las Cruces, New Mexico. In this case, we learned that McCowan was pulled over for a simple DUI. He told the police officer he had a shoulder injury, and that for reasons defying all imagination and in conflict with the idea of treating your fellow man like a human being, the officer then proceeded to give him cruel and unusual punishment. The court's words, not mine, by mistreating him, by bouncing him around in a car, and then basically ripping out his shoulder and then not giving him medical attention. The court finds that treating someone this way was clearly established at the time of the incident, and so figuring out how much is due to him is the only issue that's left, and this will go back to trial for further liability findings. Some justice may be done, and that is the end of this case.